Hello, in this video we're going to talk about the 5 basic steps to getting an estate plan in place. Hi, I'm Richard Barrett. I'm an estate planning attorney with Smith Barrett LLC, and I'm one half of the Estate Planning Guys. So your insurance agent, your financial advisor, even your parents have been telling you need to get an estate plan. You need to have a plan in place. And you're thinking, well, estate, that sounds to me like Bill Gates or the Rockefellers. I don't have that kind of stuff. I got a house, I got a car, I've got a mortgage, got some insurance. I don't need a plan. The truth is that you do. You do need a plan, and it's a sad thing that over 60% of American adults currently have no up-to-date estate plan. Why is that? I tend to think it's because they don't understand what it means. Like many of us, they may have been thinking that you have to have an estate, a gigantic millions of dollars estate in order to do planning, but that's just not true. All the plan does is make sure that your wishes for your loved ones are respected when you're incapacitated or when you pass away. So let's do an example. Let's say I have 2 kids and I'm married and I don't have any estate plan in place. Now you probably think, because it would be logical, that if I passed away, everything I had would just go to my wife, and she would use that, of course, to take care of herself and take care of the kids. And that's very reasonable. The fact is that the law is not always what you think it is, and that's the case here. If that happened in the state of Georgia in any event, if I passed away without a plan and I left 2 kids, 2 minor kids, and a wife, what would happen is my wife would be able to get a third of the property, whatever, the real estate, the proceeds that might be involved in the buyout of my position at the law firm, investment accounts, all those things. She would have a 1/3 interest, and the 2 kids, even though they're minors, would have each a 1/3 interest. That probably isn't what you thought. It may be surprising to you, but certainly it's not what most people would want, because it seems like an inconvenient and not a very good type of plan, because it's no plan. So if you're going to put a plan in place, what do you need? Well, the basics are, first, power of attorney, which is probably what you think it is. A document that's in Georgia is now a standardized form that says, this is who I am, and this is who I want to be in charge of my assets and my income, my financial life, basically, my personal business. If I can't be in charge of it, if I can't write the checks for the bills or do online bill pay or deal with the cable company, even something as mundane as that, who do I want to be in charge? Usually it's a spouse if you're married. It doesn't have to be. And then you want to name at least one backup. In addition to that, you'll want to have an advance directive. In Georgia, we used to have a living will where you put down your wishes with respect to life-sustaining treatment, and a healthcare power of attorney, which appointed someone to carry out those wishes if you weren't able to do it yourself. In 2007, Georgia started using instead an advance directive, which combines those two and does some other things as well, like deal with burial versus cremation, and do you want to be an organ donor or do you not? So it's very important because it creates or puts in place a healthcare agent for you, which means a person who, if you can't make your own healthcare decisions or can't communicate them to the healthcare providers, this person steps up and does it. So instead of having to put the decision on your spouse or on one of your kids as to whether to pull the plug, if you're permanently in a state of unconsciousness, you're terminal, the doctors know you're not going to come back, it would be hard any way around, but we hear from clients over and over again that not having to make the decision, but just conveying the decision. You put your decision, your wishes with respect to life-sustaining treatment, and if you don't want a ventilator, but you're on a ventilator and are going to be permanently, according to a couple of independent doctors, then instead of having to make that decision, the loved ones you've left behind can look at the directive and say, well, this is what his or her decision was, and they can convey that decision to the doctors or nurses. So it's a little bit it's not easy, but it's a little bit psychologically easier not to have to pull the plug or make the decision to pull the plug yourself, but simply to convey the wishes of your loved one. To go along with that advance directive, we typically recommend a HIPAA authorization, which is just a health information privacy release. It's a list of people, usually close relatives, but can be friends too, or anybody that you want. This is a list of people, doesn't matter what order the list is in. This is people who can get access to your private health information if you're not able to give consent for it yourself. So for instance, if you were hospitalized and one of your grown kids lives in Oklahoma, can't get here right away, but wants to know what's going on with dad or mom, that kid can call the hospital, and as long as you have the right HIPAA authorization in place, the doctor or nurses can speak freely with them and let them know what's going on, which can be a big relief, much better than not knowing what's going on and just having to purchase a last-minute flight and fly across the country and not know what's going on. So along with that, we usually have a personal property memorandum. And we find that people's personal property, now this isn't the bank accounts, the retirement accounts, the real estate, the cars, this is smaller items of personal property. My watch, my glasses, my tool chest, my coin collection, my stamp collection. You can, in your own handwriting, put on this memo who you want to get what in terms of smaller items of personal property, which often have only sentimental value, not even much financial value, but can be the source of a fight if nobody knows who you wanted to have that item, and there's only one of those items. The muffin tin mom used to make birthday cupcakes. The pocket knife dad always carried in his pocket. If you put those things down in your own handwriting, it's less likely, not impossible, but less likely that family will fight over it if they know that's your handwriting and it was what you wanted. Another good feature with a list like that is you can modify it in your own handwriting every day if you want to. You don't have to come pay me or anybody else to make a change to that. So those are what we call the ancillary documents, or the supporting documents of a plan. And right at the hub of the wheel, the center of the plan, is typically a will or a trust. So a will is what you think it is, right? It's a document that says, this is who I am, this is who I want to be in charge when I pass away, this is roughly what I have, and this is how I'd like it handled or distributed. The problem with a will is a will requires probate. It does avoid that problem of 1/3, 2/3 going to a spouse I would leave behind and 2 kids. So it avoids that problem by making sure that my wishes, if I want everything to go to my wife, which is a more standard sort of approach, because I don't know how much she's going to need to sustain her and sustain the kids. So instead of it going 1/3, 2/3, I can make sure it all goes to her. And then if it needs to go to the kids before they reach an age I think is appropriate, you can set some boundaries on that too, when the kids get control of the money if they do. We always recommend, well, not always, but almost always at this point, recommend a revocable living trust, which is basically, you can think of it as a bucket, a container into which you put your assets, and you retain control of those assets. But if you become incapacitated, or when you pass away, control of those assets can be passed on immediately to the successor trustee, the person you think that you want to be in charge if something happens to you. And everything in that trust, every asset, is a non-probate asset by virtue of being an asset of the trust. So you can avoid what in Georgia is often at least a 5 or 6 month process in probate, sometimes more like 8, 9, 10, 12, a year or more of a process in probate to get control of those assets. Instead, the assets in the trust can be in the hands of the person you want them to be in almost immediately if you become incapacitated or when you pass away. So those are the building blocks: power of attorney, advance directive, HIPAA authorization, personal property memo, a will, and even better, a revocable living trust to go with that. Thanks for spending some time with me. If you'd like to know how our firm can help you, please click the button at the bottom here and schedule a discovery meeting with our team. We're happy to help. I hope you enjoyed that video. If you did, please click below to subscribe and hit the little bell so you'll get a notification every time we post some. Right now, we're posting about 3 videos a week with all kinds of useful estate planning information. So click right down here so you don't miss anything about estate planning, and click right here on your screen for the next relevant video.